Hi everyone! Welcome back to the channel. Today we are diving into a topic that's become increasingly important in our digital world: privacy law. Now, privacy laws can feel complex and confusing, and there's a lot of misinformation out there. So we are here to bust there some myths and set the record straight. Hit that like button and subscribe for more tech and legal breakdowns to level up your knowledge. By the end of this video, you will be a privacy pro. If you feel like you have seen this video before, well, maybe you have. We are currently rebooting all of our content to provide for even more in-depth and high-quality content. So turn on that notification bell to stay updated. We don't want you to miss any of the awesome content coming your way. Let's get going and conquer these privacy law complexities. Alright, let's tackle the first myth about privacy law. Lots of people think it only protects super obvious personal information like your name, email address, or just your physical address. While these things are definitely covered, privacy law actually reaches much further. It goes beyond the directly identifiable things. So here is the fact to debunk myth number one. Privacy law casts a wide net. It protects a broad range of personal data, not just the clear-cut stuff like your name and address. This includes any information that can be used to identify a specific person, directly or indirectly. Think of it like this. Even if a piece of data doesn't have your name on it, if someone could put the pieces together and figure out who it belongs to, then it falls under privacy law. The data subjects are identifiable if they can be directly or indirectly identified, especially by reference to an identifier. This could be things like a name, an identification number, location, data, an online identifier, or one of several special characteristics. These characteristics have to express the physical, psychological, genetic, mental, commercial, cultural, or social identity of people. In practice, these also include all data which are or can be assigned to a person in any kind of way. For example, the telephone, credit card, or personal number of a person, account number, data plate, customer ID number are all personal data. I hope now it's easier to understand what is personal data, and we shall be moving on. Alright, let's tackle another common misconception. Privacy laws only apply to the country where a company is registered. A lot of people believe that if a company is registered in one country, it doesn't have to follow the privacy rules of other countries. In today's globalized world, data can travel far and wide. That means privacy laws are catching up. Let's explore why this myth is wrong. Just because a company is registered in one country doesn't mean it gets a free pass on privacy laws everywhere else. In our digital age, data can flow across borders easily, and privacy laws are evolving to keep up. This means companies need to be mindful of regulations, especially in the countries where they collect or store user data. For example, if your company sells goods or provides services in more than one country, it can be subject to the laws of such countries where it conducts its business operations. If it targets audience of various geographies, it can also be subject to different rules. If a company is a subsidiary, it is subject to the data protection laws of the parent company, and many other examples. So it's definitely not wise to think that you only have to comply with one or two acts in the company of registration. Our third myth to boost is that if a company is registered in one country, it generally cannot be fined for violation of privacy laws in another country. Here we go again with another common misconception. Let's debunk the myth that companies cannot be fined for violating privacy laws in another country if they're registered elsewhere. Remember how we talked about data flowing freely across borders? Well, so do the consequences for misusing it. Many countries have laws that allow them to fine companies for privacy violations, even if the company itself is not physically located there. This is because the laws often focus on protecting the privacy of people within the country, regardless of where the company is based. Just because a company is registered in one country doesn't mean they can be fined for privacy violations elsewhere. For example, in May 2023, a world-famous tech giant Meta, owner of Facebook, was fined by the EU regulator for violation of the EU privacy law known as the GDPR. Meta has been fined a record-breaking 1.2 billion euro, which is around 5.5% of the company's revenue, by European Union's regulators for violating the GDPR, by transferring the personal data of Facebook users to servers in the United States. The EU regulators said the processing and storage of personal data in the United States contravened the Europe's data privacy law, known as the GDPR. And while this fine is the largest ever even applied under GDPR, so yes, you should be mindful of all possible privacy laws applicable to you. Okay, so on to our next myth. Let's break down another misconception. Companies that don't store personal data are automatically exempt from privacy laws. This one can be a bit tricky, but here's the deal. While not storing data completely removes some concerns, privacy laws might still apply depending on the situation. Let's explore why. Here is the fact to break down myth number 4. Companies cannot escape privacy laws just because they don't store their data themselves. As long as a company collects and processes personal data, they are subject to privacy laws, even if they use a third-party service provider to store it. This is because the company is still ultimately responsible for that data and how it is handled. They need to make sure the third-party providers are also following the law. For our final myth, let's tackle the idea that a privacy policy is the ultimate shield against the privacy law violations. Do not get us wrong, a well-crafted privacy policy is a crucial step, but it's not enough on its own. Why? In this wild world of data privacy, many businesses believe a well-crafted privacy policy is the golden ticket to compliance. While a privacy policy is certainly important, it's just one piece of the puzzle. The main issue here is that privacy policies primarily explain how you collect, use, and store user data. They do not cover all aspects of the data processing required by privacy laws like the GDPR. Let me explain it to you in more detail. As we know, just having a fancy privacy policy on your website isn't enough. So what's the real deal? First of all, actions speak louder than words, and well-written privacy policy is important, but it's only effective if you actively follow through on your promises. Your company needs to implement the practices outlined in the policy. Next would be, as the saying goes, show, don't tell, because privacy regulators aren't looking for pretty words. They want to see the evidence that you are taking user privacy seriously. This could involve things like security audits, data access procedures, and a clear demonstration of accountability for how user data is handled. Finally, remember, a privacy policy is a crucial step, but it's just the beginning of the journey towards the real privacy compliance. So this is all myths for today. I have specifically chosen these ones because I get asked these 5 questions more than I can count. So now I hope you have the answers to these questions for yourselves and you are ready to begin your compliant journey. I would be really glad to assist you on the way. Please like this video and let me know by clicking the like button, subscribing to my channel. You can also allow notifications for my new videos so that you do not miss anything. Thank you and see you very soon.